Good afternoon, this is Sean Golding with Golding & Golding, here to answer the very common question we receive of whether or not a client is going to go to jail or prison for not filing the FBAR. Generally, people do not go to jail for not filing the FBAR, most of the time it's going to be a civil non-willful or civil willful violation. When it comes to criminal, it's a much different stage than it is for civil. For civil, the IRS or the U.S. government specifically just has to show preponderance of the evidence, which is more than 50%, more likely than not. When it comes to criminal, first of all, it's not enforced by the IRS. It's going to be referred by the IRS over to the special agents and then to the U.S. Department of Justice or something along those lines. When it's enforced through that mechanism, it's your regular criminal case. So an indictment or complaint is filed, the defendant gets a jury of his or her peers, and they have to show beyond a reasonable doubt. So quantifying different standards of proof, preponderance of the evidence is more than 50%, clear and convincing evidence is more than 75%, beyond reasonable doubt is 95% because it's a loss of freedom. I can tell you in the 20 years I've been practicing, it's extremely rare that anyone comes to us with a criminal FBAR situation. In most situations, when criminal is involved, it's because the client is already under criminal investigation for other related issues, whether it's something with structuring or smurfing, whether it's some type of money laundering, just a tax evasion, tax fraud, criminal, different type of crime. The reason why it's so uncommon is because with civil, let's take civil willful penalties. It's preponderance of the evidence, and the government doesn't have to show intent. So there could be reckless disregard, willful blindness. Okay. When you're dealing with the criminal aspect of it, they have to show beyond a reasonable doubt, and willfulness requires intent. So it's a much harder burden. So for an individual that may have a couple $100,000 overseas, unless there's some really egregious facts and circumstances, chances are it's not going to get to that level. The IRS would rather just hit them with civil willful penalties, which are pretty often given in the last few years and upheld by many courts. People have tried to defend that the regulations aren't clear. People have tried to say a memo that was circulated back in 2006 said it should be clear and convincing evidence, but the courts really haven't been moved at all on those issues. If you think you may be subject to criminal, you were willful, it might be a gray line between whether it was intentional, reckless disregard, willful blindness. There is the voluntary disclosure program. There was something called OVDP, which was for offshore related activities, FBAR, FATCA, PFIX, things like that. OVDP was closed in 2018, which some people don't know, thanks to all the inept attorneys out there giving incorrect advice, is that the IRS also expanded the voluntary disclosure program in 2018 and 19. Under the new versions of the program, the new pre-clearance letter, voluntary disclosure, which was primarily used for domestic related activities, is now used for both domestic and offshore. One very important key issue is that you have to submit before you're under audit or investigation. Otherwise, the IRS has the right to reject you. Again, my name is Sean Golding with Golding & Golding. We have gobbles of information for free on our website, goldinglawyers.com. You can always schedule a reduced fee initial consultation for 30 or 60 minutes if you're interested. Thank you for your time. Have a good rest of the day.